I usually cover cases involving the Constitution of the United States. Today, however, I'm looking at a case out of the state of Illinois involving that state's constitution and the question of county gun and ammo taxes. Now, while the appellant's complaint argues that these taxes violate both Article 1, Section 22 of the Illinois Constitution and the Second Amendment to the U.S. Constitution, the Illinois Supreme Court instead focused on the taxing power of the county. While Cook County gun owners may be happy with the outcome, as a constitutional scholar, I find the majority opinion woefully lacking. So we'll discuss that next on the Constitution Study.
One thing you have to know wherever you make your stand came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. I'm glad you could join me. This is where we read and study the Constitution. We teach the rising generation to be free. You've still got a little bit more time. I'm going to be in Tampa the 9th and the 10th. I've got 2 events scheduled. If you want to find out more, go to constitutionstudy.com/tour and see if you can join us. And if you've got other places you'd like me to come speak to, I've been speaking to a lot of groups lately. By all means, fill out the form on that page, and we'll see if I can come speak to your group as well. It's very important that we get to understand not only what our rights are, but how do we defend them for ourselves, because let's face it, government's not doing that job. We'll talk more about that later. For now, let's talk about these Illinois gun and ammo taxes. The case of Gun Save Life, Inc. versus Zahar Ali, director of the Department of Revenue of Cook County, brings up an interesting question. Is a tax on a constitutionally protected right an infringement of that right? Now, the case stems from 2 Cook County ordinances, one that imposes a $25 tax on the retail purchase of a firearm within the county, the other a tax on ammunition of 5 cents per centerfire cartridge and 1 cent per rimfire. Gun Save Life, Inc. claims that these taxes violate both the Second Amendment to the Constitution of the United States and Article 1, Section 22 of the Illinois Constitution, which reads, "Subject only to the police power, the right of the individual citizen to keep and bear arms shall not be infringed." While the court looked at several legal issues regarding the case, I'm focusing on the constitutional questions involved. From the opinion, we begin our analysis with the Illinois constitutional claims and need not consider the federal constitutional claim, as we find dispositive that the taxes violate the uniformity clause. See, the court decided not to even consider the violation of the rights to keep and bear arms under the constitutions of either Illinois or the United States. Rather, the court focused on the issue of uniformity. See, Article 9, Section 2 of the Illinois Constitution states, "In any law classifying the subjects or objects of non-property taxes or fees, the classes shall be reasonable, and the subjects and objects within each class shall be taxed uniformly. Exceptions, deductions, credits, refunds, and other allowances shall be reasonable." The court then notes that for a non-property tax to survive its scrutiny, it must be based on a real or substantial difference between the people taxed and not taxed, and bear some reasonable relationship to the legislation or public policy. It is the second of these requirements where the court found problems with these ordinances. Here, the entity responsible for justifying the tax, the county, maintains that the tax classification is justified since a reasonable relationship exists between the special tax and the object of the ordinance. The preferred justification for the taxes is to fund the staggering economic and social costs of gun violence in Cook County. The court asserts that firearms and ammunition are instruments of death and that their harmful effects cost the county immeasurably in terms of health, safety, and welfare. The county claims that the taxes are reasonable because of the amount of money it pays to treat gunshot wounds. The county claims it spends between $30 and $40 million per year, and since 25% of those patients do not have health insurance, well, the county must pick up the cost of their treatment. The county also claims that firearms and ammunition are instruments of death and are therefore harmful to public health, safety, and welfare, which means these taxes are a source of revenue for gun safety and violence prevention programs, along with the funding of the criminal justice agencies that combat gun violence. The court, however, found something different. We agree that the ordinances impose a burden on the exercise of a fundamental right protected by the Second Amendment. At its core, the Second Amendment protects the right of law-abiding citizens to keep and bear arms for self-defense in the home, according to District of Columbia versus Heller. While the taxes do not directly burden a law-abiding citizen's right to use a firearm for self-defense, they do directly burden a law-abiding citizen's right to acquire a firearm and the necessary ammunition for self-defense. Guns Save Life, Inc. relied on the Boynton versus Cusper case to claim that an ordinance may not single out the exercise of a fundamental right for special taxation to raise revenue for the general welfare. They claim that the revenue raised by the taxes do not specifically fund gun violence prevention measures, rather the proceeds go into the county's general fund. In this language, the court hides a lie in the middle of the truth. Yes, taxing something imposes a burden on it. Therefore, taxing a right protected by the Constitution imposes a burden on the exercise of that right. However, the court did not accurately describe either the Second Amendment or the Supreme Court's Heller opinion on which they were relying. The Second Amendment protects an individual right to possess a firearm unconnected with service in the militia, and to use that firearm for traditionally lawful purposes, such as self-defense in the home. So in the Heller decision, the Supreme Court attempted to limit the plain language of the Constitution when it recognized that the Second Amendment protects an individual right to possess firearms for traditionally lawful purposes, of which self-defense within the home is one. However, the Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Constitution does not limit the lawful purposes of firearms to self-defense in the home. The right to bear arms means the right to carry, therefore extending the right to use outside of the home as well. Neither does the Second Amendment limit the use of arms to self-defense. Noah Webster defined arms in his 1828 dictionary as weapons of offense or armor for defense and protection of the body. The Second Amendment protects the right to keep and bear arms, not just firearms. That means your right to carry knives, swords, chemical sprays, or basically any arm. Now, the court has already admitted it was not going to consider the Second Amendment issue because it found a problem with the taxing issue. Applying that standard to the firearm and ammunition taxes, we recognize that the Uniformity Clause was not designed as a straitjacket for the county, and acknowledge the cost that gun violence imposes on society. Nevertheless, the relationship between the tax classification and the use of the tax proceeds is not sufficiently tied to the stated objective of ameliorating those costs. Under the plain language of the ordinance, the revenue generated from the firearms tax is not directed to any fund or program specifically rated to curbing the cost of gun violence. Additionally, nothing in the ordinance indicates that the proceeds generated from the ammunition tax must be specifically directed to initiatives aimed at reducing gun violence. Thus, we hold the tax ordinances are unconstitutional under the Uniformity Clause. According to the court, the problem with these ordinances is not that they infringe on a right protected by the constitutions of both the state and the United States, but that the tax singles out a group of people without being used for the stated purpose of the tax. It appears to be the court using the tax question to skirt the central issue of infringing on the rights of the citizens of Cook County, Illinois. While the decision of the Illinois Supreme Court was unanimous, Justice Burke included a special concurrence. I agree with the majority that Cook County's special tax on firearms and ammunition violates the Uniformity Clause of the Illinois Constitution. Therefore, the appellate court's judgment must be reversed and summary judgment entered on behalf of the plaintiffs. I write separately because I believe there's an even greater problem with the county's tax that the majority should not ignore. While I agree that there was a much graver problem with the county's tax ordinance that the court should have addressed, it is not the one that Justice Burke wrote about. As numerous Illinois cases explain, under our state constitution, the power to regulate and the power to tax are separate and distinct government purposes. While the government may regulate the right to keep and bear arms within other constitutional limits under its police power, by the plain terms of Article 1, Section 22, it has no authority to single out the exercise of that right for taxation. Justice Burke points out that the Illinois Constitution does not allow the government to single out the right to keep and bear arms for taxation, only to regulate it under their police powers. Now, my problem with the justice's analysis of the right to keep and bear arms falls squarely on the Supremacy Clause, Article 6, Clause 2 of the United States Constitution, which reads, "The Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The Constitution clearly states not only does it supersede the Constitution of the state of Illinois, but that the justices of the Illinois Supreme Court are bound to it. While the Illinois Constitution may subject the right of the individual to keep and bear arms to the police power, the Constitution of the United States does not. Therefore, the government may not regulate the right to keep and bear arms, period. Anything else is both a violation of the justice's oath of office and a crime under Title 18 of the United States Code, Section 242. Now, in my opinion, Justice Burke also points out a serious problem with the way the court went about finding these taxes unconstitutional. The majority's analysis is problematic because it leaves space for a municipality to enact a future tax, single out guns and ammunition sales, that is more narrowly tailored to the purposes of ameliorating gun violence. Specifically, the majority states that the tax ordinance fails to pass constitutional muster only because the relationship between the tax classification and the use of the tax proceeds is not sufficiently tied to the stated objective of ameliorating the cost that gun violence imposes on society. The majority then admonishes that revenue generated from the taxes is not directed to any initiative or program directed at curbing gun violence or reducing its costs. The only problem with the majority's approach and the guidance it offers to the county is that such counsel, if followed, would still violate the provision of the Illinois Constitution noted above that plainly states that the right of the individual to keep and bear arms is subject only to the police power, not the power to tax. See Illinois Constitution from 1970, Article 1, Section 22. Thus, the majority is leading the county down a road of futility. Rather than a road to futility, I believe the majority of the court has mapped out a plan for the counties in Illinois to violate the rights of their citizens in a way the court would uphold. All Cook County or any government within the state of Illinois has to do to make these taxes acceptable to this court is earmark the revenue collected to something related to gun violence, such as violence prevention programs, or to offset the cost of the county's healthcare system. This is why I say constitutional scholars must trust but verify. Simply reading the headlines around this case would lead one to believe that the Supreme Court of Illinois had stood up to defend the rights of the citizens of their state. Instead, the court found a picky little problem to focus on while ignoring the larger issue of constitutionally protected rights and placing signposts for the state and the county on how to infringe on those rights. By sidestepping the plaintiff's main argument that these taxes violate both Article 1, Section 22 of the Illinois Constitution and the Second Amendment of the Constitution of the United States, this court has not only denied the members of Gun Save Life, Inc. their right to petition the government for redress of grievance, but the right to due process as well. While some may claim the decision upheld the right of Illinois citizens to keep and bear arms, it did nothing of the sort. I would urge those citizens to consider that when these justices are next up for election. Another example of the devil being in the details. Sure, it sounded great. Yay, the state of Illinois Supreme Court upheld your right to keep and bear arms, but it didn't. It just said, listen, Cook County, the way you're done these taxes isn't right. You got to fix them. This is not uncommon in judicial opinions, but it misses the entire point. They completely ignore the entire keep and bear arms issue, which was the major complaint and the main reason Gun Save Life, Inc. filed this suit. So again, we see the right to keep and bear arms and the right to petition your government for redress of grievance is once again under attack, while many gun activists are cheering this opinion. I think if we do that, we'll find that we'll be sorely disappointed when Cook County figures out all they have to do is change the ordinance to say, hey, we're going to earmark these monies for gun safety programs or to offset the cost of gun violence. Once they do that, according to this court, they'll be more than happy. That's why we need to trust but verify. It's why we need to read and study. It's why we need to understand and then use that to educate others. Now, as I mentioned, I'll be in Tampa on the 9th and the 10th talking about knowing your rights. And again, you can find more at constitutionstudy.com/tour. But I'm also working on a nationwide Constitution study. I'll be doing it online. Now, if you want to find out more, go to constitutionstudy.com/study. It's a whole process set up. There's a whole page with a lot of information about it. And I'm working on some other things as well. So if you want to find out more, head to the website, sign up for the newsletter. They were some of the first people to find out about these new programs. Most of all, if you would do me a favor, take this episode, In fact, take any episode you like and share it with friends and family. Anything that's on the Constitution Study website is there for you to use and there for you to share absolutely free. And if you want to find out more, well, just head over there and ask. Click the Ask a Question button and I'll be more than happy to answer it. Or join me twice a month for my live Q&As. You can find them on Rumble, YouTube, Twitter, and hopefully pretty soon locals.com as well. Or you can go to the website and register for the live Q&A and you can join me on the Zoom call. However you do it, let's make sure your questions are being answered. Let's use that as time to educate ourselves and encourage ourselves on what to do. Most of all, I hope you enjoyed this. I hope you found it educational. And I hope you'll join me next time for the Constitution Study.